Okay, greetings and welcome to the Quarles and Brady webinar, Back to Basics, Corporate Immigration Strategies and H-1B Alternatives. My name is Maria Kallmeyer and I'm a partner in the firm's immigration group. I'm co-presenting today with two attorneys who are also on our immigration team, Nneka Umai and Emily Scherso. Our immigration team advises large and small businesses on all aspects of employment-related immigration law, including employment strategies, corporate immigration compliance, including I-9 and E-Verify, physician immigration, and visa processing for all foreign national employees. Nneka, Emily, and I are pleased to be with you today. Before we get started, a few housekeeping items to go over. You may access a copy of today's presentation and other forms and materials in the handouts panel of the webinar dashboard. We will be applying for 1 hour of CLE credit. If you are an attorney and would like to receive CLE credit for attending today's presentation, please fill out the CLE form found in the handouts on the dashboard and return as directed. HR professionals will also find attendance certificates for today's webinar in the handouts provided on the dashboard. We have muted all phone lines for those dialing in and for participants listening to audio via computer, so you will not be able to speak. We are in listen-only mode. We would like you to be aware that this presentation is being recorded and an electronic survey will be emailed to you after the program. If you have a question during the presentation, please type your question in the Q&A box located in the upper right-hand corner of the webinar dashboard and submit. The conference host will make sure the speakers receive the message. Every effort will be made to answer questions in the final minutes of our time together today. Okay, with that, we will move forward. So this seminar is called Immigration Basics, and it is just that. It's meant to be basics, a foundation for those less experienced with immigration law, or a refresher for those who need it. I'm going to start today with an overview of immigration law and the agencies that touch on immigration. Then Emily is going to discuss the non-immigrant categories, and Nneka is going to discuss green card options. We'll all talk through a few hypotheticals to give you some real world examples of kind of how we apply all this wonderful immigration knowledge. And like I said earlier, we're happy to answer all your questions at the end. So starting with the agencies, there's several different agencies that touch on immigration, and what's interesting is that they don't all necessarily talk to each other. So it's helpful to know, you know, when you're at various points in the immigration process, what agency is it that you're talking to, and what is the goal of that agency and the role of that agency sort of in the greater immigration context. So, of course, there's the Department of Homeland Security. Department of Homeland Security was created after 9/11. It replaced the former Immigration Nationality Service, and it split the immigration functions into 3 separate agencies. So the first is Citizenship and Immigration Services. That's the agency that actually grants immigration benefits. So if you want to apply for an H-1B for somebody or for a green card application, you file a paper application by mail to this agency. They review the content of that application and either approve it or issue an RFE or deny it. The second one, Customs and Border Protection, they are actually trained as a law enforcement agency, and their goal is to decide what is allowed into the United States, what and also who. So they are the ones at the border deciding whether or not immigrants are allowed into the United States. And what's helpful to know is that they only receive about 6 weeks of actual immigration training. So a lot of times you might have a foreign national who comes to you and says, you know, I tried to enter the US yesterday and I was detained and the immigration officer told me something and I don't know if it's right. And it might in fact not be correct because they don't have that much training. Like I said, they're trained as a law enforcement agency. So it's helpful to be aware of that. Immigration Customs and Enforcement is responsible for interior enforcement of immigration law. If you ever get an I-9 audit, it is ICE that would be at your office with the audit paperwork. They also deport people, so if you ever find a foreign national who's in immigration court, they are the agency that's on the prosecution side in immigration court. The next larger agency that deals with immigration is the Department of State. Of course, the Department of State is responsible for foreign policy and foreign relations. They run the embassies and consulates around the world. They're responsible for granting visas. That's the actual visa stamp in someone's passport that allows someone to actually come to the U.S. So I like to think of them as they decide who gets a ticket into the U.S. They don't decide all the details later, but they are the agency that decides who gets the ticket. They're responsible for initial background checks on people. You may have heard the words extreme vetting in the news lately. The Department of State is the agency who would be doing that additional vetting to decide whether or not someone gets a ticket or an initial visa stamp to actually come into the U.S. The Department of Labor, of course, is not really an immigration agency, but they do play a role in immigration. They're responsible for the labor condition application or the pre-certification that's necessary for H-1Bs and also that labor market test. That's the first step in green card applications that we'll talk about later. I think what's most helpful to understand about the Department of Labor is their goal in this is really to protect U.S. workers. They're not trying to facilitate a program for foreign nationals. They want to protect U.S. workers and make sure that if you're hiring a foreign national and sponsoring a foreign national, that you're also doing right by your U.S. workers and paying those foreign nationals enough. The Department of Justice, I hope no one on this call ever has to deal with it, but they run the immigration court system. So if a foreign national finds themselves in deportation proceedings, those proceedings will happen under the Department of Justice. And finally, it's not on the slide, but I think it's worth mentioning also the Social Security Administration and the local Department of Motor Vehicles. They also don't deal directly with immigration, but if someone's applying for a Social Security card or a driver's license, they're going to try to verify that individual's immigration status by looking in a Department of Homeland Security database. So they don't have access to the entire Department of Homeland Security database, and they might not understand really what the details are of those immigration statuses, but they do have to look and at least try to verify that someone has an the proper immigration status. So moving on, the immigration law is really organized into 3 levels under the Immigration and Nationality Act. The first level is the most obvious, as U.S. citizenship. So of course, you know, we have U.S. citizens here. The next level is called the immigrant visas or legal permanent residence. So legal permanent residents can do anything in the U.S. that a citizen can do except for vote or commit certain crimes. And then the next category of people, sort of the largest category that we deal with, are the non-immigrants, or the people who are here for a specific period of time for a specific reason, after which they're supposed to return home. So, and then there's the fourth group that we don't hear about as much because it's, of course, not, well, we probably hear about it more, but it's not written into the Immigration and Nationality Act. It's that group of undocumented people. And the reason they're undocumented is because they don't fit well into one of these categories that we're going to talk about now for the rest of the presentation. So the non-immigrant categories, like I said, are people who are here for a specific period of time for a specific reason. The Immigration and Nationality Act is actually organized by letter. We sometimes call it the alphabet soup of immigration options. If you call us with a scenario or a foreign national you want to bring into the U.S., this is what we're thinking. We're thinking, okay, the law allows for all these different categories, and how can we fit your person and your scenario into one of these categories? So this is a high-level overview of all the different categories we're going to talk about, and now I'm going to turn it over to Emily, who's going to get into some more specifics about the various different categories.
Thanks, Maria. So as Maria just mentioned, there truly is a wide variety of temporary visas for various activities in the U.S. But this morning, I really want to focus in on specifically the U.S. employment visas, and also just highlight some of the more common work visas that you can utilize in your companies and organizations. So the most universal work visa is truly our H-1B visa, which is highlighted on the screen here. This visa is for professional workers. Sometimes it's referred to as the specialty occupation visa. So substantively, in order to qualify for the H-1B visa, the first prong is the employer must require a minimum of a bachelor's degree or its equivalency in a specific field of study. And that specific field of study must be directly related to the proposed job duties. Then secondly, the employee or the beneficiary of that H-1B petition must possess at least that bachelor's degree that's required or its equivalency in that specific field. It's important to note that the H-1B sponsorship is for a specific job, for a specific employer, and a specific location. So if there's going to be a material change in job duties or location, often we have to notify USCIS of that material change. So a lot of times employers will get into trouble when, unbeknownst to them, one of the employees has changed locations, maybe they're now working from home, and you hear about it months later. And all of a sudden, if USCIS shows up at your doorstep and the employee is not there, then we run into an issue. So under the current administration, we're seeing an increase in site visits. So it's really important to reiterate to your foreign national employees, their managers, HR counterparts who might be in charge of immigration, you need to be kept in the loop of when there is a proposed change in job duties or in work location, just so that we can then take the necessary steps to remain compliant. So one of the biggest challenges of the H-1B program is actually a procedural challenge. So in order to sponsor someone for an H-1B visa for the first time, so these are cases where the individual has never held H-1B status in the past, the employee must first be counted against the annual H-1B cap. USCIS only issues 85,000 new H-1B visas each year. So in order to be considered under this H-1B cap, the employer must first file that initial H-1B petition on April 1st of that year, requesting October 1st as the start date. The past few years, USCIS has received enough H-1B petitions within that first week after the cap opens. So this filing deadline is very, very critical. And the challenge we have is that the demand for these visas is just astronomically higher than the actual supply. So this year we had just over 190,000 H-1B petitions under the current lottery filed looking to fill these 85,000 slots. Once the H-1B cap closes, the government conducts a random lottery to select enough petitions to fill those 85,000 slots and then continues to adjudicate. Once someone is lucky enough to actually be in H-1B status, they can hold that H-1B status for a total of 6 years. So it's still a temporary work visa. The first H-1B validity period will be valid for up to 3 years, and then the employer or another employer can continue to extend that H-1B status until that 6 years is met. There is an exception to this rule. Once an employer initiates green card sponsorship and we get far enough along in the process, we can extend that H-1B status beyond those 6 years, but NECA will touch on that as well when she discusses the green card sponsorship. An additional requirement for the H-1B sponsorship is that the employer must pay a salary higher than either the prevailing wage or the actual wage. So the prevailing wage is established by the Department of Labor. They set the different wage levels based on complexity of the job, seniority of the position. And the actual wage is set by your particular company. So if you employ 15 chemical engineers, they earn $90,000 to $100,000 a year. That's your actual wage that you're paying people in those similar positions. So again, the employer needs to pay the higher of either the prevailing wage or the actual wage that's set by your company's practice. Finally, there's also a posting requirement. The employer must post details regarding the H-1B petition, which includes the salary offered at the proposed work location. And the employer must also maintain a public access file that needs to be available upon request, and that, again, includes additional details about that H-1B petition. So under the current administration and the executive order to really protect U.S. workers, we've really seen U.S. Citizenship and Immigration Services turn up the heat when they're adjudicating these H-1B petitions. Specifically, USCIS is looking very closely at whether a position qualifies as a specialty occupation. So they want to make sure that the position truly requires an actual degree in a specific field to perform the proposed job duties. They're also looking at the wages of these H-1B petitions. So they're looking especially at positions where we're indicating that they're making the lowest possible wage that we could pay someone according to the Department of Labor standards, and then arguing that this position might not be a specialty occupation because it's so entry level. So those are some of the challenges that we're facing when looking at H-1B petitions. But however, even in light of these challenges, the H-1B petition, as I mentioned, is still a great option because it can be universally applied to many industries, many companies, it's transferable. But again, our biggest hurdle is just getting selected in the H-1B lottery in the first place. Currently, USCIS has now conducted the annual lottery from our April 1st filing. We're continuing to receive receipt notices on a daily basis for petitions letting us know that those have been selected. But don't fret if you haven't received one yet, we're still receiving them on an ongoing basis. So even if you haven't received a receipt notice yet, there's still a chance that it'll still be selected in the lottery. But over the next couple weeks and months, we're going to be getting the results, and we're going to know that there are some employees who are not selected in the H-1B lottery. And so we need to start thinking creatively of different options for these employees to continue either work authorization in the United States or with your company. So now, in light of this upcoming challenge, I just want to highlight some other work visas that might be a viable option in these situations. The first is the L-1 visa program. This program is for companies with a global presence, multinational presence. So companies that have entities, parents, companies, subsidiaries, affiliates around the world in various countries. And the L-1 program allows for companies to transfer relatively easily, or the initial intent was for it to be relatively easily, to transfer these employees who have been employed for at least 1 year in a specific capacity at one of the qualifying foreign entities outside the U.S. So looking at employees who've been employed outside of the U.S. At either the parent, subsidiary, or affiliate. There are two different types of L-1 visas. The first is the L-1A, and that's reserved for our managers, executives who again have served in this managerial capacity for at least 1 year outside of the U.S. and looking to transfer them to the U.S. to again serve in that managerial capacity. We can show managerial authority in two ways. The first is the more traditional way where the individual has direct reports, they're overseeing supervisory positions or professional individuals. The second way is we can show that somebody has managerial authority over a major essential function within the company. So you might not have direct reports, but you may indirectly oversee personnel in relation to the function, that essential function that you manage. The second type of L-1 visa is the L-1B visa. And in order to qualify for the L-1B visa, we need to show that the individual has, quote, specialized knowledge. And the way that we try to define this slightly vague term is we need to show that someone has specialized or advanced knowledge of proprietary technology, procedures, processes that are unique to the company itself. We also need to show that the person not only has specialized knowledge in comparison to others in the industry, but also within your company itself. So how are they different than their peers? Then again, the person needs to be transferred to the U.S. to serve in a specialized knowledge capacity as well. These individual L-1 petitions are filed with U.S. Citizenship and Immigration Services. And once they're approved, the individual employee must then apply for the L-1 visa stamp at the U.S. consulate or embassy abroad, and then they can enter in L-1 status. In terms of the length of the L-1, Somebody in L1A status can be in L1A for 7 years. So the initial L1 will be granted for 3 years, and then you're eligible for 2 subsequent 2-year extensions. Someone in L1B gets a total of 5 years. So the initial is 3 years, and then they're eligible for that 2-year extension. Unlike the H-1B, we're unable to extend the L status beyond those statutory 5- and 7-year periods. There are certain companies that operate at a certain level. They have 3 global entities. They frequently utilize the L1 program. They can be eligible to apply for what's called the L blanket, or the blanket L approval. This is essentially sort of a pre-approval of the qualifying corporate relationships and other L1 requirements. And we are asking for pre-approval from U.S. Citizenship and Immigration Services. And once this is approved, it allows the employees who are applying under this blanket to sort of shortcut the system, and they can take their application packages directly to the U.S. Embassy or Consulate and apply for their L1 visa there. So we don't need to first file with USCIS. So we're able to cut away lengthy processing times. It allows companies to transfer employees more easily under that blanket approval. Additionally, generally, we find that the officers at the U.S. consulates and embassies are a little more lenient in their adjudication. If they have additional questions, the employee is right there in front of them. So we, again, can sort of shortcut those lengthy processing times than filing with USCIS. One additional thing to note is that filing under the blanket for an L1B, the applicant or beneficiary needs to have a bachelor's degree in order to qualify. And finally, one of the perks of the L1 is that the L2 spouse, so the dependent spouse on L2 status, can apply for independent work authorization, which would allow them to work for any employer in the United States. So as an H-1B alternative, some of our clients use the L1 visa program as a longer-term solution. So if in a case where a company might currently employ a student who's graduated from university, they've exhausted their work authorization, they were not chosen in the lottery, and the company will actually transfer the employee to one of their locations outside of the U.S. for at least that 1 qualifying year. During that time, we can start building our case for that L1 petition, gathering evidence we know that we're going to have to show. And then after that year of qualifying experience abroad, we can look to apply for the L1 and transfer them back to the United States. Another popular work visa is the TN visa. So the TN visa is derived from the NAFTA treaty. So this visa is reserved for Canadian and Mexican citizens. The treaty itself specifies various occupational positions that qualify for the TN visa. So this includes categories such as engineers, computer systems analysts, librarians are on the list. And often there's a misconception, I think, that as long as you're from Canada or Mexico, you have a bachelor's degree, you're going to be guaranteed a TN. But we need to keep in mind, especially under the current administration, that they're really reinforcing or enforcing these occupational classifications that are spelled out in the NAFTA treaty. So for example, in the past, we used to be able to classify financial analysts under the economist occupational classification. But recently, USCIS published a memorandum specifically barring this exact practice. So they're really looking and honing in on what are the job duties of these occupations, and do the proposed job duties actually fall under one of these categories. As a professional visa, most of the occupational classifications require a bachelor's degree in a related field. Some require post-secondary diplomas or certificates with some additional experience. Again, they're specific to the occupational classification that we're looking to file under. The Canadian citizens are able to apply for their TN status directly at the Canadian border, the US border or airports. The Mexican citizens must first either file with USCIS or go to the US Embassy or Consulate and apply for their TN visa stamp. TNs are generally issued in 3-year increments or up to 3-year increments, and there's actually no limit on how many times we can renew the TN visa. However, in order to qualify for the TN, the beneficiary needs to maintain their non-immigrant intent. So this means that they cannot intend to permanently immigrate to the US. So when we start renewing 4, 5, 6 times, this starts putting question marks as to whether this person is truly intending to return to Canada after their temporary work in the United States. So the TN is a great alternative to the H-1B if your employee happens to be a Canadian or Mexican citizen and they happen to be performing the job duties in one of the occupational classifications, and it's also in line with their education. The O1 visa is an interesting visa. It's reserved for, it's a temporary work visa, again, and reserved for those with extraordinary abilities in either businesses, sciences, arts, athletics, education, and it's truly reserved for those in the top echelon of one's field. So in order to qualify for the O1, we need to show that the beneficiary has risen to the top of their field. So for example, we can either show that you've won a Nobel Prize, or in the alternative, we can satisfy at least 3 of the 8 possible evidentiary categories that are outlined in the regulations. So interestingly, these categories were drafted most likely more with academic fields in mind. So they're geared more towards scientists, towards researchers. So we have to get a little more creative for positions that don't seem to fit this mold of these academic fields. For example, some of the evidentiary categories, we can show receipt of major awards, scholarly publications, reviewing the work of peers, features in major media, and evidence of original contributions. The O1 visa is also valid for up to 3 years and eligible for indefinite 1-year extensions of that same position. Again, there's no limit on how many times we can extend, but just like the TN, we do need to maintain that non-immigrant intent. So once we have someone who's been in the US for several years, we might want to look to changing them more towards the green card track if they're looking to stay more permanently. So the O1 is a really interesting alternative for the H-1B, especially if you employ researchers, scientists, employees who are publishing patents. It's a good option to look at if someone is not selected in the H-1B lottery. And finally, I just want to touch on the B1 visitor visa. This actually is not a work visa, not to be confused with our other options, because visitor visas, or those here on a visitor visa, should not be engaged in actual productive work while in the US. Activities should really be limited to attending meetings, trainings, if you're participating in litigation. Again, the work product cannot benefit the US company, so we cannot be engaged in productive work while in the US that would benefit the US company. Some individuals do not require an actual B1 visa stamp in their passport. So if they fall under the visa waiver program, the individuals only need to enroll in an online system, and then they're able to travel to the US as a business visitor to attend their meetings or trainings or whatever they need to do that's compliant with the B1 requirements. So now I'm going to turn it over to Nneka, who's going to discuss some of our student work authorization options.
Hi, everyone. So I'm going to talk about the F1 student visa. Most frequently, you'll see this in terms of their work authorization. One thing to keep in mind about the F1 student visa is that university involvement in getting this the work authorization approved is related to confirming that the individual's work will be related to their field of study. There are several options for the F1 work authorization, and we have more alphabet soup here. They can be on CPT, OPT, STEM OPT, and another one that's not listed, but that's related to the H-1B lottery is CAP-GAP. For CPT, you're most likely looking at someone who's still attending their academic program. This person will probably be a summer intern, although there are some exceptions. With this, the individual will go to their university and request approval of the CPT work authorization and will be issued what's known as a Form I-20. For that, you can use it while you're attending school. But once you've graduated, we see most people that are working in the US as an F1 under the OPT program. The OPT also requires university approval, so that individual will still go back to their university designated school official and obtain an I-20 to approve the work that they have planned. The additional step here for OPT is that you must then go to USCIS and apply for an employment authorization document. We commonly refer to this as an EAD card. Another big difference here is that EAD card must be in hand before that individual can begin working for you. So if someone brings you a receipt notice saying, you know, my case has been approved, you still want to make sure that they have that physical card in their possession before they start their employment with you. The next option here is for the STEM OPT. This refers to individuals who have graduated in the U.S. with degrees in science, technology, engineering, and math. Again, that individual would go to their designated school official at their university and obtain a Form I-20 approval in order to apply for that STEM OPT EAD card. One thing that's been added to the STEM OPT program is a training program requirement. The individual will have to work with you to obtain a Form I-983 that's completed. You have to show that you'll be evaluating the individual's work, that they'll be learning tools that they can use, again, that are related to their major field of study within science, technology, engineering, or math. And then they'll take that I-983 and the approved I-20 and show that to the designated school official at their university. Again, they do have to apply for an EAD card with USCIS. The difference here is that the individual can continue working once that EAD application is filed. So that's unlike the OPT where they have to have their EAD card in hand. I know those are a lot of acronyms, so feel free to reach out if you have any questions about CPT, OPT, or STEM OPT. The last one that I do want to talk about here within the F1 student visa work authorization is CAP-GAP. So as Emily noted previously, everyone submits their initial H-1B petitions to USCIS during the first 5 business days of April of every year. And then you hopefully are selected in the lottery and then later receive confirmation that your H-1B has been reviewed and approved. Once you get that H-1B approval, you can't start working on it until October 1st of that same year. So for individuals who do not have work authorization between April 1st and October 1st of that year, USCIS allows you to obtain CAP-GAP. This is obtained through your university, again, by obtaining an I-20 from your designated school official. You can take evidence of your filing of the H-1B petition to USCIS under the lottery and submit that to the university so that they'll issue you an I-20 that covers your work authorization from April 1st until September 30th. If you are not selected during that H-1B processing time, your CAP-GAP would end on June 1st. One more thing that I wanted to add about the F1 is the new guidance that we've received from USCIS regarding unlawful presence. Previously, F1s and other visa types that we'll talk about shortly were able to stay in the U.S. And even if they were out of status, but continue to remain in the U.S. without fear of being immediately deported. With this new memo that has been issued, the government has now let us know that as of, I believe it's August 20th of 2018, if you are out of status, meaning maybe you've been unemployed while you've had your OPT or STEM OPT for more than the allotted time, that you are accruing unlawful presence. That is a big change in the policy for USCIS because unlawful presence, once you've been in the U.S. and have accrued a certain amount of unlawful presence, you can be barred from re-entering the U.S. for either 3 or 10 years. So it's important to reach out to your F1 work authorized employees and make sure that there are no gaps in their employment if they are on OPT or STEM OPT. And then if they've maybe missed a semester, that you're working with them through that to determine that filing a subsequent petition for them won't cause them to have to leave the country immediately due to unlawful presence concerns.
Right, thank you, Nneka. So moving on to J's, J visas are also subject to that new unlawful presence memo that that Nneka just mentioned. And I think what's really most important there is, like Nneka said, to understand that distinction between being out of status and unlawfully present. So When a person is out of status in any non-immigrant status, they are violating their status. It is an immigration violation, but I would consider that more of a minor immigration violation. When you reach the level of unlawful presence, that's a major immigration violation that could land that individual to be barred from the country for 3 to 10 years or even forever. So it has a much more grave issue, and now F1s and Js are going to be facing that issue, and it's something that we want to talk about and know about with them and make sure that people are following their program correctly and not falling out of status. So the J1 program. J1s it's actually a Department of State program, and going back to my first slide about the agencies, the point of the program is to facilitate international exchange. So it's written into the law specifically as an option so people can learn something in the US and bring that back to their home country. There are many different categories within the J program, but I think that's the overarching issue and the overarching thing to think about. When the Department of State is granting someone a J, their purpose is so that they're going to return to their home country and use that knowledge at home. So sort of skipping to the bottom of the slide, many times J's come with what's called a 2-year foreign residency requirement. And that requirement is for the foreign national to actually return to their home country or their country of last residence to use the skills they learned in the United States. So that is actually a requirement of a visa, and you want to know about that. Let's say you're trying to hire a new employee on an H-1B and they had a J in the past. Anytime you hear someone has had a J in the past, you want to know, well, were you or are you subject to that 2-year foreign residency requirement? Because if they are subject to that 2-year foreign residency requirement, they're going to either need a waiver of that requirement, and those waivers are available, but they are something that we have to actively apply for and obtain, or they're going to have to return home for 2 years and fulfill that requirement to use the knowledge they gained here in the United States back home in their home country. So a few of the categories we see: research scholars. Those are usually people who are going to universities or research organizations to do some type of research. Physician training. So more than half of physicians who come to complete residency or fellowship programs in the United States come on J1 visas, and they are subject to that 2-year foreign residency requirement. There is also an intern and a trainee program. So the trainees must have a degree from a foreign university, not a U.S. university, or they must have 5 years of work experience. And then they really have to explain why they are coming to the U.S. to participate in a training program that's going to benefit their career abroad. So that's really the distinction, is if you're an employer who's applying for a J1, you have to explain what is the training program you have them here in the U.S. to do, and how are they going to use that experience to benefit their future career abroad. The intern is very similar, except for it's for students who are currently enrolled in a foreign educational program, or they're within 12 months of their graduation. So as an H-1B alternative, this comes up fairly often. People ask, can we get a J1? If it's someone who has gone to school in the United States and they were prior in the F1 status prior, and then they didn't get an H-1B in the lottery, it is probably not going to work because of that foreign degree requirement. But if it's somebody who does have a foreign degree, it may be an option to get them here to work as a trainee or an intern for a year or up to 18 months until maybe they apply in the H-1B lottery again. Although I should add that those two intents are conflicting, because when you have somebody here on a J, like I said, the intent is for them to return back and pursue their career abroad, and obviously filing an H-1B is not consistent with that intent. So that's something to be aware of and think about. There's also au pairs that are here are typically on J-1 visas, or it's also used for camp counselors. There are many other categories that aren't mentioned, but they're all about facilitating exchange. So that wraps up our non-immigrant categories that we're talking about. Now, just to make sure you're not asleep yet, we're going to talk about a hypothetical, and hopefully you'll follow along with us. And Emily is going to pose the hypothetical, and Nneka and I are going to answer.
Great. So you either are HR manager, in-house counsel at a global company. You have locations across the world. You have a location in Toronto, Canada, and your U.S. engineering team is looking to transfer one of the engineering managers who's based out of that Toronto location to the United States to work for the U.S. company as soon as possible. So often when we're posed with these scenarios, the first thing that we need to do is just get some additional information, ask more questions. So Maria, in light of these facts presented, what additional information would you be looking for, both from the company as well as from the potential employee?
Sure. So first I want to know, what is the nationality of the individual? I understand that he or she works in Canada, but is he actually a Canadian national with a Canadian passport? I want to know what the U.S. job is and the U.S. salary. How long has that person worked for the company in Canada? Are there family members that we should consider in our discussion? And what are the long-term plans for that individual? As well as procedurally, I want to know, does the company have a blanket L that would make an easier procedural option?
Great. So in response to these questions you've posed to the client, you receive additional information that, yes, he is a Canadian national. He's a single guy, has a home in Canada, looking to come to the U.S. maybe for just 2 years at most. So he's not looking to permanently come to the United States. He does have a bachelor's degree in electrical engineering. They're looking to pay him about $150,000 a year. He currently in Canada oversees a team of 10 professional engineers. He spends the majority of his time managing their work. He is coming to the U.S., so they want to bring him to the U.S. to manage a team of additional 8 electrical engineers, all who have bachelor's degrees. He will again spend the majority of his time managing these employees. So Nneka, in light of this additional information we've acquired, which visa type would you recommend would be the best option for this company and for this employee?
Well, given that the business probably wants him here as soon as possible, as in yesterday, the most cost-effective and quickest option for us will probably be an L1A petition. Because the individual is a Canadian citizen, he has the benefit of being able to go directly to the border to submit his petition and have it adjudicated on that same day. Since this is an L1A petition, if he happens to change his mind later in life and maybe he finds someone wants to settle down here in the U.S., we do have the option of a green card that has some benefits for us that dovetail nicely with the L1A petition. Let's talk about 2 other options that we may have considered but aren't as quick or cost effective. One would be the TN petition that we can also file at the border, so it is quick. It's also around the same cost, so it's cost effective. But because this individual is coming to the U.S. to perform managerial duties, we may run into an issue with CBP at the border, and that's customs. Some CBP officers are not so hot on managers in TN positions, so we don't want to have any potential conflict with CBP and have him turned away. So we'd pursue the more safe option of the L1A. And depending on the time of year, the H-1B may not work for this individual because, again, if he's never held an H-1B before and it's sometime other than the beginning of April, then we'd have to wait until April 1st to file an H-1B in the lottery. Then we'd have to hope that he is one of the 85,000 spots that are selected in the lottery. And then we'd have to wait for USCIS to review and approve that petition. All of that to then wait until October 1st for him to start. Again, given that the business wants the individual here as soon as possible, H-1B probably isn't going to be a time-effective choice. And then the filing fees for an H-1B are significantly higher than those for either the L-1A or the TN, because both of those can be processed at the border.
Great, thank you.
So next we'll talk about my personal favorite, green cards. So why do people want green cards before we talk about how you can get them? So green cards have a lot of benefits. One is that you no longer have limits on your status in the U.S. like you would with a non-immigrant status. Another is that you're no longer tied to a specific employer. Third, you don't have to go to a consulate to renew your travel authorization every few years like you do for most of your non-immigrant visa options. And then finally, you no longer have to worry about filing for work authorization. If your employee gets a green card, they can continue to work for you even past the validity date of their green card that they have in their physical possession. So green cards do work out well for the employer and the employee, but let's talk about how you get them. There are 4 major ways to get a green card. The first of those that we won't touch on in more detail in this presentation, but that you most likely have heard of, is a family-based sponsorship. So this is related to having a spouse, parent, child, or sibling that is a U.S. citizen and in some instances a permanent resident or a green card holder. You would file a petition with the government, or that family member would file a petition with the government for you, and then you would file an application to actually adjust your status. That one can take a long time depending on the backlog of applicants for the family-based sponsorship. So we consider that in some instances when we have employees that have married a U.S. citizen, and so maybe that's the quickest option for us to get the employee permanent work authorization so that the employer no longer has to renew that individual's visa status every few years. Next, we have employment sponsorship. This is the one that we see most frequently. There are several categories of employment sponsorship, but we'll talk about 3 here in a bit. Employment sponsorship, as it states, requires that the employer wants to employ you indefinitely. So for that one, there are some hoops that some agencies make us go through, and we'll discuss those in more detail. For the diversity visa, that's one that anyone can apply for. You apply at a certain time of year, then the government lets you know that you've been selected, and then once you confirm you meet certain requirements, you attend an interview at the consulate outside of the United States, you come into the US, and then you are mailed your green card. For asylees, refugees, victims of domestic violence, and others, there are specific procedures for applying for your green card. That's not one that we handle very frequently here. Most frequently, we do handle that employment sponsorship and then that family-based sponsorship. There are requirements even after you obtain a green card. Some of those are that you can't leave the U.S. for a long period of time. So individuals can't get their green card and then move back to their home country for several years and then come back into the U.S. Without notifying the government ahead of time that that is their intent. You have to pay your taxes every year, just like all of us U.S. citizens. So, the permanent resident status still has that requirement because the IRS does want their money. And then finally, you cannot commit certain crimes. Hopefully your employees are not committing any crimes, so we won't get into details about what those crimes are. Okay, so let's talk about the employment-based green card categories. You guys probably hear these frequently when an employee comes to you and notifies you that they want to start their green card process. Most people usually want to be an EB-1. I don't know that everyone knows what an EB-1 is, but they want it because it sounds good. It's the first category. So let's get into more detail about what that category actually means. There are 3 levels of EB-1 petitions. The first is multinational managers, and this one is dovetails nicely with the L-1A. So if you have an L-1A employee that has worked for at least 1 year abroad in a managerial or executive position and is in the U.S. performing either a managerial or executive position, then they will likely qualify for that multinational manager classification within the EB-1 category. The next one is outstanding researcher. This one dovetails somewhat nicely with the O1. This is, let's say we have someone who's obtained several patents, they're published in a lot of journals, and they also have, reviewed other articles from other authors in journals within their field. Then you're probably looking at an outstanding researcher. One thing to note here about outstanding researchers, even if you are not a research organization, if you have a research department, or maybe there are individuals within your company that conduct research on a regular basis, then we may still be able to go through the outstanding researcher process for that sponsored individual to obtain an EB-1 green card for them. And then finally, we have extraordinary ability under the EB-1 category. As Emily mentioned before, this is similar to the O1 in that the USCIS will probably consider you eligible if you have a Nobel Peace Prize. If not, then there are those other 8 categories that you can pick and choose from to demonstrate that you qualify for that EB-1. The EB-1 process looks nice in the beginning because it does have fewer steps, but it is more labor intensive in terms of supporting documents if you're looking at either the outstanding researcher or extraordinary ability categories within the EB-1. The next option is the EB-2, and I'll talk about this in conjunction with EB-3 because EB-2 requires that your job description for this sponsored individual requires at least a minimum of a bachelor's and 5 years of experience or a master's degree in order to perform the job duties that are listed within that job description. So again, your bachelor's or your master's degree must be related to that job description that the individual is being sponsored for. But the EB-3 is everything else. So let's say your job description requires a bachelor's degree and 4.5 years of experience. That person would fall under the EB-3 category. Just to provide a timeline of how the employment-based green card process works, overall, there are 3 major stages. The first is the Department of Labor stage. Again, they want to protect U.S. workers. So they do have us go through some regulatory requirements to confirm that there are no U.S. workers that are qualified, available, and willing to perform the position as described in the green card job description. There are several hoops to go through, but they're very regulated and regimented. So if you complete all of the steps successfully, you then go into the next stage with USCIS, and that is the I-140. The I-140 is essentially the employer's notification to USCIS that you intend to sponsor this employee for this particular position. You will note that the EB-1 does not have to go through the PERM process, which is another reason why it's the catch of the day for the green card process. But they do have to go through the I-140 and then the last stage, which is the I-485. That I-485 is actually the application by the employee to adjust status from non-immigrant to immigrant or green card holder. For those last 2 stages, the I-140 requires that the employer show that they have the ability to pay the employee the wage that's required. And then we also have to show that the employee qualifies for that sponsored role. Right now, the government is taking between 10 and 13 months. I hesitate to say that because it still hurts. They used to be at 5 months processing time, but that has increased significantly. This is the only stage in the entire green card process where you can opt to expedite the processing time by paying an additional $1,225 to USCIS for premium processing. And then the final stage of the green card process is Form I-485, as I mentioned previously. And this stage involves a lot of background on the employee, their residence history, their employment history. And for anyone that's ever been asked, this is where the dependents join the green card process. You file that I-485 for the employee as well as any dependents that they have in the U.S. Unfortunately, that processing time is also increased significantly due to the employment-based green card interviews that are now required at the USCIS local offices around the country. Once those individuals obtain their green cards, as I mentioned before, they will use that green card as their U.S. work and travel authorization, and they no longer have to renew visas outside of the U.S., and you no longer have to file petitions to extend their work authorization while they are in the U.S. So with that brief overview of employment-based green cards, let's go through an immigrant hypothetical. For this one, you work for a biotechnology company. A Japanese foreign national accepted an offer to work for you as a genetics researcher and indicated that she might need employment sponsorship. Then after, of course, you bring her on, you find out that her OPT card expires on August 1st of 2018. So you filed an H-1B for her in this most recent lottery. Let's say you just found out that she was not selected in the lottery, and then she gives you another piece of information, which is that she's engaged to marry a U.S. citizen on July 6th of next year. And she also just found out that she received a U.S. patent for her genetics widget. With all of the information that you now have, what can you do to maintain the employee's work authorization, Maria?
Well, I really like this foreign national because she has lots of options. The first one that I would think about is what is her degree in? We know that she has that optional practical training OPT card that is expiring in August, but I would be willing to guess if she's a genetics researcher that she has a science degree or an engineering degree, and she is probably able to get a STEM extension on her OPT, which will give her another couple of years to continue working. So that really solves the short-term problem of allowing her to continue to work. And then I would think about, well, we could put her in the H-1B lottery again next year, which would be a great option, or we could move straight to a green card application, either through her U.S. citizen marriage. Generally, getting a green card through a marriage is the most easy and straightforward option, so that is generally the one we would select. However, she also has this patent for her genetics widget that makes me think she might also be eligible for that EB1 outstanding researcher option, so it would also be worth a review of her resume to see whether that is a viable option for her. It's also a fast way to get a green card if she is truly qualified as outstanding. So thank you all for continuing to listen. We have just a few minutes left, and we do have a couple of questions. We'll start with the questions that we already have, but if you have more, please send them along, and we're happy to stay for an extra few minutes to answer questions. So the first question I'll take, and that is, it says, F1 students often want to start businesses, which can be questionable while on F1 status. Would starting a company be considered unlawful presence? That's a great question, and I think the real honest answer is that we don't know yet. It is a new memo. The unlawful presence memo that NACA mentioned is a new memo. It just came out last Friday, and we don't know exactly how it's going to be adjudicated. But I think the key point to think about there is that it is going to have to be adjudicated. So practically, this type of issue is going to come up when maybe you file an H-1B change of status for that individual, and we get an RFE on the H-1B asking if the individual maintained their F1 status. So starting a business when your intent in the U.S. is supposed to be a student may not, USCIS may not consider that maintaining status, and they could consider that person out of status. So I think it's a risk, and I certainly wouldn't advise someone to do that, but whether or not it will be adjudicated as unlawfully present, I think remains to be seen. I certainly hope not, because that would be a harsh reality for many people. Okay, the second question. If an employee is applying for an EAD, that's Employment Authorization Card renewal, and it hasn't arrived by the time their original EAD expires, can we simply put them on unpaid leave until the EAD renewal arrives rather than terminating them? And Emily, you want to take that question?
Sure. So to clarify, if somebody is renewing, if they have a current OPT EAD, and they're looking to renew by filing that STEM extension, if they have a degree in one of the STEM fields, as long as they file their renewal before their current OPT expires, their work authorization is actually automatically extended for 180 days while that STEM extension is pending. So you don't have to put them on administrative leave necessarily if we're waiting for the STEM OPT to be approved. So you'll want to update the I-9, you want to re-verify with that receipt notice of their I-765 filing, but you don't need to put them on administrative leave in that situation. Conversely, if somebody is working pursuant to CPT, that curricular practical training, so they may have just graduated and they had that curricular practical training while they were completing their studies, if they're awaiting their initial EAD OPT, then yes, they do need to have that EAD card in hand before they can continue working for you. So in that case, yes, you can go ahead and put them on administrative leave in that situation.
Another thing to keep in mind about EAD cards is that they run the gamut. They're not only for F1 students. We also see EAD cards for individuals who are the dependents of an L1 visa holder, and then individuals who are the dependents of an H-1B visa holder once that H-1B holder has gotten to a certain point in the green card process. We also see EAD cards for individuals that have a green card process pending with USCIS, and while they're waiting for that to be adjudicated, USCIS has issued them a temporary work card in the form of an EAD so that they can continue their employment. And each of those have varying automatic extension options. So you'll want to look specifically at the EAD card and confirm what category that EAD card was issued in to determine whether or not they are eligible for an automatic extension.
Okay, great. And with that, we're going to wrap it up. We did get one other question about when will the HRCI recertification material be posted, and we'll follow up on that one by email. Thank you, everybody, for participating, and our contact information is on the last slide. Feel free to reach out with any other questions you have. Thank you for joining.